All right, welcome back, everyone. So back for an encore is Professor Gerry Beyer presenting on what every Texas estate planner needs to know about firearms. So please join me in welcoming back Professor Beyer.
All right, everybody, I haven't seen you all in a while. Good to see you again. And as you know, the verdict on the ballot is you wanted to know about firearms. But not all of you wanted to hear about firearms, right? Some of you don't care. So what we're going to do is we're going to start with 3 other recent estate planning developments, just so you can see something a little different. All right. Now, one of the choices you had to select from was estate planning for people who own pet animals. And some of you perhaps have heard me speak about that before. But there's a new thing, and that is estate planning for people who own plants. Okay? There's getting to be a movement now that people are concerned that their geriatric houseplants will not get proper care after they die. And so this is a brand new blooming area of the law. Yeah, that was bad. Now, wait a minute now. I just made that up right now as I was talking. Never even thought about it before. Maybe I should think these things out a little bit before I talk. Anyways, but that's an actual provision from a will where people are now starting to leave money, perhaps in trust for the care of their plants, a new area of estate planning. Now the next one, you know, your estate plan that you plan for a client takes effect when the client dies. But of course, you don't want to rush the death. What happened in this case is you're looking at a gentleman by the name of Walter Williams. No, not the famous columnist, but just another person with the same name. And he was declared dead. And they stuffed him into the body bag. And then they took him to the funeral home where he was going to be embalmed. And many hours later, the funeral workers got around to him, and they noticed that the bag was sort of wiggling around. And inside, old Walt was struggling to free himself from the darkness inside. And the workers there at the crematorium, they let him out. And he said, you know, can I just go to the hospital, make sure I'm okay? They took him to the hospital, and his condition was upgraded from dead to alive. And he went home. Now, later on, poor Walter died again. And this time, do you know his family? Took him to the same funeral home again. But this time, he didn't make it. All right. And our last thing, I want you to take a look at this. Now, many of you, I'm sure, have a Google account. How many of you have some Gmail or Google or YouTube, some account? Okay. Now, buried in the fine print is what happens upon death. And I want you to read this together with me. Upon the termination of your use of Google services, including upon receipt of a certificate or other legal document confirming your death, Google will close your account. So far, so good. Then it says, and you will no longer be able to retrieve content contained in that account. Okay? So, if you're dead, and they have to tell that you cannot get content from your account anymore, in my mind, they must fear something. What do they fear? Zombies, vampires, because who else would be declared dead and then would attempt to withdraw money from the account? So they put all sorts of strange things in the accounts. There are some other stories. I've been trying to get them proved. I don't know if they're just urban legend. This one I know is real. I even have the link there so you can go see it for yourself. But I've heard others that one company said that you've given up the right to your firstborn child. That's in the user agreement. And another one said, if you call this number, we'll send you $500. And it took 5 years before someone found that, called, and claimed the $500. All right. Well, enough of that now. What we're all here to talk about are weapons. And just take a look at the prevalence of weapon ownership. 43% of Americans keep guns in their homes. Texans own over 50 million firearms. 20% of all the firearms in the United States are right here in the great state of Texas. So we are an armed state. And then there are also over about 250,000 machine guns and other National Firearms Act weapons that are registered. And it is extremely important to plan for different types of weapons to be sure that the intent of your client is carried out, as well as to make sure that your clients and their family members do not end up in getting in trouble under federal law. We're going to divide our presentation this afternoon into looking at two different types of weapons. We're going to look at the non-NFA weapons, the so-called regular weapons, and then we'll look at the NFA or Title II weapons, which definitely need a lot of special planning. With that in mind, let us first start looking at planning for the non-NFA weapons. These are things like your traditional revolvers, pistols, rifles, shotguns, etc. Now, what kind of planning do we need for these? The transfer of these types of weapons are predominantly governed by state law. So the beneficiary must be able to possess under local law where the beneficiary lives. Now think about it. How many of you draft wills for people and the beneficiaries live in other states? You ever write a will and the beneficiary lives outside of Texas? Sure. Well, if that happens and you're leaving them even these traditional weapons, you have to ascertain whether or not they would be allowed to own them in their state, perhaps even county or city of residence. Look at the requirements under Texas law. You can't know the beneficiary intends to use the weapon in an unlawful manner. The beneficiary cannot be under 18 unless you have written parental permission. The beneficiary cannot be convicted of a felony or certain other misdemeanors. Well, the requirements are not uniform among the states. And if you would leave regular weapons to people in other states, maybe they're not authorized to possess them. I mean, they get them under your will, they bring them home, and now they're criminals. So you don't want to do that. So you have to make sure, under the local law of the jurisdiction where the beneficiary of your normal weapons resides, whether they would be able to own the weapon legally. Because the odds are they're going to bring it home to where they live. So some of the things you will want to do is conduct a background check. You'll want to do a background check of the intended beneficiary because you may not know of their criminal history, even if the beneficiary is your child. Have any of you hid your arrests from your parents? Anybody ever hide an arrest from a parent, not tell them they've been picked up? Yeah, none of you are going to admit it. But I'll bet you it could be true. So you should do a background check and make sure that the beneficiary would indeed be a proper owner under state law. And of course, name some alternates as well. Always a good idea to have some alternates in case the intended beneficiary turns out to be ineligible. Now that's about all that you need to think about. We'll talk some more about putting it into a trust later. But generally, with regular weapons, your biggest concern is to make certain that the beneficiary you picked is able to lawfully possess and own the weapon in their city, state, and county of residence, and then, of course, name alternates. And you have to keep an eye open because things can change here. State laws can change, and what the beneficiary's conduct has been may change as well. The primary focus of our presentation is to look at National Firearms Act weapons. Now, the National Firearms Act of 1934 was enacted in response to the violence that accompanied Prohibition. Anybody know in what year did Prohibition end? That's close. 1933. 1933. Well, you see a couple of things about... Well, look, if I go home and ask my mom when Prohibition ended, she remembers when it ended. Yeah, she was 11, living in Chicago at the time where all the stuff happened. So she remembers, oh yeah, I remember Dad said he could drink again. You know, my grandfather. So, you know, one remembers, okay. Anyways, well, you can also see the government in action. They enacted this because of the violence that accompanied Prohibition. Prohibition ended in 1933, they enacted this act in 1934. A little late. I mean, they'd already ended the act was there because of prohibition problems, but prohibition is already over by the time they got around to enacting it. And this act then governs purchase, sale, transfer, ownership, use, and possession of weapons that are under the purview of the National Firearms Act. This is one of the main acts that we have to be concerned with as we do planning for NFA weapons. You also have to pay attention to the Gun Control Act of 1968 that was enacted in response to the assassinations that occurred during that period of time, and also the Firearm Owners Protection Act of 1986 that allows the transfer of machine guns that were lawfully possessed as of May 19, 1986. With all that in mind, the first thing to do is to ascertain what types of weapons are governed by the National Firearms Act. We'll start first with machine guns. A machine gun is a weapon that can automatically fire more than one shot without manual reloading by a single pull of the trigger. In other words, you pull the trigger once and it continues to shoot either till you take your finger off the trigger or it runs out of ammunition. In addition to machine guns themselves, it also covers parts that can convert a regular weapon into a machine gun. That small part you're looking at is called a sear, and if that part is properly affixed to a weapon that it's designed to be affixed to, that can convert a gun that only shoots one bullet per pull of the trigger into a weapon that can fire multiple shots with one pull of the trigger. So these parts also have to be registered under the National Firearms Act. The next thing governed by the NFA are short-barreled shotguns and rifles. These are weapons with a barrel less than 18 inches in length or a total length of less than 26 inches. These are the ones you always see people carrying under their trench coats that they pull out because they're short enough that they don't drag on the ground when they walk. Next, silencers or suppressors that make the sound of the weapon quieter. What is very interesting is that in many nations, these are not prohibited with weapon ownership, they are mandatory. Because in many countries, people don't like the noise. So they want people to have silencers. I mean, that's part of what you have to do because they don't like the noise. In the United States, they're not. But there is a huge number of states now, an increasing number of states, that if you do own a silencer legally, you can use it when you hunt. Because, you know, the noise from a gun will scare away your prey, and this way you can track down your prey a bit easier if your gun makes less noise. Oh, it has nothing to do with this. During lunch, I was just looking at something. It has nothing to do with guns. It has to do with criminals. Close enough. And this guy, he called up the police and accused his wife of stealing his cocaine. And then they arrested him for cocaine. You know, that's like saying, oh, look, my marijuana has stems and seeds. I want my money back. And then suing. You know, you just don't quite do that, at least in Texas. All right, anyways. So the next NFA weapon are all the concealed type weapons. You know, the James Bond kind of weapons. The ones inside of gloves and air pressure gauges and inside of a cane and all those sorts of things. And then some very heavy-duty devices are also covered, and that would be your grenades, your landmines, your poison gas bombs, and all those sorts of things. Of course, I don't think you'll have clients, I hope, owning those types of things. So let us talk about the typical type of weapons, NFA weapons, that your clients might own. That would be a machine gun, a sear that converts it, a suppressor, or a short-barreled weapon. Does anybody themselves or clients they know own these types of weapons? Yeah, you see, it's quite prevalent, especially in... This is always interesting, too. I've given, you know that list I gave you of topics to talk about? I've given similar lists to people in other states when I speak. In some states, they actually tell me, don't put that on the list. We don't countenance anything about weapons in our state, like I was speak in California, and they take that off the list. Don't even put that on the list of things. They'll never let you come in and talk. And in other states, it's the first thing they pick, like you guys. Arizona wanted guns too. They wanted weapon discussion. Just all depends where you live. Anyways, so let's talk about transferring an NFA weapon. Assuming you legally own an NFA weapon, what about transferring it? Big pain is the answer. You have to complete an ATF form number 4. That's not too bad. Then you got to pay a $200 tax. Now I want to talk to you about the $200 tax. The $200 tax, unlike probably any other tax you've heard of, has never been raised since it was enacted. It was enacted in 1934. What they really wanted to do was take everybody's machine guns away from them. The government really wanted to confiscate them. But you can't do that, right? You can't just take the property away. So what they did is imposed a huge fee on transfer. Because if you would take $200 in 1934 and inflation adjusted, it is about $3,500 in today's money, which meant to transfer the weapon was more money than the weapon was worth. So they figured by imposing this huge tax, which $200 was back in 1934, by imposing this huge tax, they would stop people from being able to transfer the weapons, and hopefully the criminal element then would not get a hold of them. But like I said, it's fascinating that of all the taxes around, that one they've never raised. It's the same as it was when it was originally enacted. The next thing you need to do is you need to get a signed certificate from the Chief Law Enforcement Officer. Signed certificate from the Chief Law Enforcement Officer, which is, it could be the sheriff, it could be a judge. You need a duplicate set of forms with original signatures. You need your photographs, and you need your fingerprints. 2 FBI forms FD-258 with all your fingerprints that they send off to Washington and enshrine in folders and such. Now, from a practical standpoint, when you look at that, it doesn't, there's a lot of stuff you got to do, but it doesn't sound that onerous until you look at the third thing on the list, which is to obtain a signed law enforcement certificate. There are many judges, many sheriffs, and other officials that will not sign them for political reasons. Because what? They are very afraid of that they sign off on one of these, and then the person who receives the weapon goes and commits some heinous crime, goes on some shooting spree. It's very interesting to note, though, that as far as I've been able to research, very few, if any of the terrible shootings that have happened with NFA weapons. They happen with non-NFA weapons. Because most people who own NFA weapons are what? What are most of them? Why do they own them? Because they are collectors. Right. They like to collect them. Some of them don't even shoot them. They just like to collect them. Some will shoot, and of course, if you ever go to Vegas and have nothing better to do, you can always go out, and they have some ranges where they'll let you shoot all the automatic weapons and blow up stuff. I've never done it. Have any of you ever done that in Vegas? Have you at least seen the signs? Okay, but you haven't done it yet. Thinking about it? You're thinking about it. All right. You got to let me know how that goes. All right. So the point of all of this is that this is a very difficult process, and it is especially difficult because it's hard to get the signatures of the chief law enforcement officer or a judge. And there is no legal method to force them to sign. In other words, if they won't sign, they don't need a good reason. They don't need any reason not to sign. They just don't do it. All right. And then if you do something wrong, you don't want to do something wrong. Because look at what happens to you if you do something wrong. Well, you get 10 years in the Iron Hotel, so 10 years in prison, $250,000 in fines potentially. You forfeit the weapon, and you forfeit any vehicle that you use to convey or conceal the weapon. So the penalties for not following the requirements of the NFA are extremely high. Now we have to think about, too, some of the ways people can get into trouble without actually even appreciating the problem they're getting into. Because if you are illegally an owner of an NFA weapon, it is only you that can possess. And we need to address both the issues of innocent possession and constructive possession, because both innocent and constructive possession are potentially in violation of federal law. So, let's assume that you go over to a friend's house, and the friend is an owner of an NFA weapon, 100% legal, and they have it hanging above their fireplace because Granddad pried it out of the hands of a dead Nazi during World War II. And this is the spoils of war. This is the family heirloom. And you look up at it and you say, wow, is that cool? Can I hold it? And maybe you can take a picture of me, or I can take a picture of myself, a selfie there, holding that machine gun. And they say, sure. And now you hold it. That is now in violation of federal law. You are not the owner. I don't care that it's unloaded. It is in violation of federal law, and you could potentially be in trouble. Likewise, constructive possession is possible. Let's just assume that you have Granddad's machine gun that he pried out of the hands of the dead Nazi in your house. And it's in your office at home, sitting there, everything is fine. But you got other people living with you, like your spouse. Well, your spouse has access to the room in which the machine gun is hanging on the wall. That is constructive possession. And he or she may not be the owner, and so that could potentially be in violation of federal law. You can probably imagine that there are these violations that occur on a regular basis, and people don't get into trouble because, there's no one looking around. But you never know when that could happen, and you don't want to tell your clients, yeah, what you're doing is illegal, but you just might not get caught. Right? You can't do that. It's like say, yeah, go ahead and sell marijuana. You might not get caught. Go ahead and speed. You might not steal. That's okay. Just don't get caught. So it's about the same thing here. You can't advise them that, oh, yeah, that's okay for you to have it there and let people touch it. That violates federal law, but it's okay. You can't do that. So that gives you some problems. So now let's assume, just for a second, we'll take a different approach on this, is that a client has died, and you are now trying to administer the estate. And you start going through their stuff, and you find this, you could always imagine it's in the basement somewhere, and you're going through the floor, and you find the door, and you pick up the door, and you crawl down, and there's the big vault. Have anybody ever seen that? They've gone in, and they found all the weapons. Some people I know in the audience actually have had similar events happen where they found a huge cache of the weapons there. So now, what do you do if you find an NFA weapon after the person dies? Well, what you need to do is ascertain if it has been properly registered. That's step number one. Was it properly registered as an NFA weapon? Now, if you don't know, you can contact the ATF, the Alcohol, Tobacco, and Firearms folks, and they'll be very glad to check it out for you. You give them some serial numbers and model numbers, and they'll check it out for you. So you look for the registration document among their valuable papers, maybe the safe deposit box or whatever, and if you can't find anything, you contact the ATF. Now, if you don't find a registration document, and if the ATF doesn't confirm that it was registered, then you just got to turn it over to law enforcement. That's it. That's it. You cannot register them retroactively. You can't say, oh, okay, I'll be glad to follow all the procedures now. It doesn't work. You cannot register these weapons retroactively. And if you do not act quickly enough, the executor, the family members, etc., could be deemed in violation of federal law because they are now possessing these weapons, and they are unregistered NFA weapons. A very scary situation to be in, and I've talked with many people who have had to take these weapons, which had either A, high monetary value, or B, high sentimental value because they're heirlooms, and they've had to give them to the ATF, and they just get destroyed. Has that happened to anybody? Every once in a while in the audience, I see one or two people where that has happened, and that's kind of tragic. Now, if you find a registered weapon, you breathe a big sigh of relief because now you know the weapon was legally held by the decedent and you can now proceed to transfer it. Now, the executor or administrator will now be responsible to transferring it to the appropriate heir under intestacy or will beneficiaries. Of course, you know that this causes all sorts of problems. I mean, when you die intestate, you don't get divided shares and stuff, right? Everybody is a tenant in common with regard to everything. So if there are 4 kids and a spouse that are heirs, perhaps because it's separate property, each one of them has an undivided interest as a tenant in common on that weapon. And if it's a will beneficiary, what if I leave the residual to my kids and you got a bunch of kids? Again, each one has an undivided interest in that weapon. So they are all now owners of that weapon. You have a reasonable time to make the transfer. How do you figure out what a reasonable time is? Well, there's nothing in the statute that tells you what the reasonable time is, though from the people I have talked with anecdotally, they tell me a year from death. They usually say about a year from death, the ATF won't get twisted out of shape about it. So that's the reasonable time. If you take longer than that, the personal representative, remember, the personal representative has the right to possess the entire estate as the estate exists on date of death. The personal representative could end up being deemed in unlawful possession if they retain it for too long a period of time. What's nice, though, is a transfer at death like this you don't have to pay the tax, but you still have to do an awful lot of paperwork, which makes it burdensome on the personal representative. Accordingly, what you should give extreme serious consideration to if your client owns any NFA weapons is the creation of a gun trust. A gun trust is probably the best estate planning technique you can use for someone who owns an NFA weapon. So how does a gun trust operate? Well, first of all, the NFA allows it. I mean, we got express authorization in the National Firearms Act to allow weapons to be registered in the name of a trust. So what you would do is then transfer the weapons to the trust. And this is a very easy process. The gun owner simply applies directly to the ATF for the transfer of the weapon to the gun trust. Look at all the things that are not needed. You do not need the signature of a law enforcement officer or judge. You don't need photographs, because how do you take a picture of a trust? You don't need fingerprints. A trust doesn't have fingerprints either. And they don't have to worry about getting the signature of a law enforcement officer or judge to make that transfer. So that makes things considerably easier. Then, you can use the gun trust for both regular weapons and NFA weapons. You will find that many of your clients who own NFA weapons are also owners of standard regular type weapons as well. And although you don't need the extensive provisions of a gun trust necessarily for regular weapons, it certainly is a good vehicle for handling non-NFA weapons as well, because hopefully you now have trustees in place who are weapon savvy and would be able to handle both types of weapons effectively. Then, the gun trust gives the trustee possessory and use rights. So the trustees may legally possess and use the weapons, and the successor trustees are given the same rights. And you could even allow the trustee to appoint new trustees. So this allows you to let your friends use the weapon. If the trustee has the ability to appoint another new trustee, then the guy comes over or the woman comes over and says, yeah, I want to use the weapon. Let's go to the range. You sign a trust amendment and you make them a trustee. Now they're a trustee. Now they can go use the weapon. When you're done for the day, you go back and you revoke their designation as a trustee. No, I mean, that's what you do. So you can change the trustees on a regular basis, or maybe you do it by changing the beneficiaries, but you can have powers in there so that you can change the trustees and therefore allow others to use the weapon. Now, when you Another great thing is the gun trust can be used for previously owned and newly acquired weapons. Like I said earlier, many of the people who own NFA weapons are collectors, and they like to go to the gun shows. How many of you have ever been to one of these gun shows? Okay, so they go to the gun show and they see these machine guns. They're from World War I, World War II, Vietnam, Korea, all these places, and they say, it would be really cool to add that to our collection. Well, if you have to go through and the dealer has to get the signature of a chief law enforcement officer and all that other stuff and the fingerprints and the photographs, that's going to be virtually impossible. But if you already have a gun trust, you just say, I'll buy it right now. You can fill out the forms and register it in the name of the gun trust, which makes things very easy for people to purchase additional NFA weapons to add to their collection. Then, at the end, after most likely the death of the original owner, the trustee can determine if the ultimate beneficiary is an appropriate owner. We already talked about the importance, even for regular weapons, of making sure the beneficiary under the state law in the state in which the beneficiary lives has authority to own the weapon. Well, the requirements to own an NFA weapon are very, very lengthy. Let's take a look at those. And again, this allows the trustee to make that determination at the time of the settlor's death, the original owner's death, because these circumstances could change so much. Look at them. Under indictment or convicted of a crime punishable by imprisonment for over 1 year. That doesn't mean they were in prison for over 1 year. It just means that over 1 year was a possible punishment for the offense. Or they're a fugitive from justice, or an unlawful user of or addicted to any controlled substance. This is getting to be a real big issue now, right? For the people who live in Alaska, Colorado, Washington, and Washington, D.C., right? You know a little too much about where to... Is that your spring break? That's your road trip. Yes, road trip. Let's visit every state, get some stoner brownies, right? That's what you need. All right, they said we have a dessert bar later on. Don't know. If we were in Colorado, it would be a legitimate question to ask. Anyways, so what about that? That's, by the way, although that's an issue aside from here, that's really big. Well, how do you practice in those states where recreational marijuana use is against federal law, but it's okay under state law? And, does that prevent you from, glad we don't have to worry about it here. Reefer Madness rules. So, anybody ever seen that movie? Yeah. Oh, that's sad. More of you need to see it. It's really good. It'll make sure you never use marijuana. All right. It was a propaganda film made in the 30s, I think. Pardon?
The original title was Don't Tell Your Children.
Don't tell your children. There you go. Anyways, so it's pretty cool stuff. Anyway, how come you're more interested when I talk about drugs? All right. Anyways. Also, you can't be I apologize for the language. This is in the federal statute. It's really old. It's really non-PC anymore. Adjudicated as a mental defective or committed to a mental institution, being an illegal alien, being dishonorably discharged from our military, be a person who has renounced their United States citizenship, someone subject to a restraining order. Now think about that. Lots of people are subject to restraining orders. It's a very common thing in a divorce action or child custody situation. Even when there's no big threat, you get a unilateral restraining order for a short period of time. So that could cause trouble. Or convicted of domestic violence. So it's very important that the trustee make sure that the person they're going to deliver the weapon to is an authorized holder. And then even if they are, they can make sure that the beneficiary is sufficiently mature and responsible. You don't want to hand a machine gun to someone who you don't think can handle it. And then if the designated beneficiary is someone who the trustee thinks is not a proper person, then the settlor can provide instructions for finding a proper beneficiary. So that works very well. And there's some other great benefits you can get. It reduces constructive possession risks, because in the house, you can name your family members as authorized users. You can name people who come to visit that you want to be able to, hold the gun or use it on the range. You can name them as authorized users. So you stop those worries about constructive possession risks. And you can protect it for multiple generations if you want. Rather than just using the gun trust to transfer the weapon from parent to child, for example, you could use a gun trust to keep the guns in the family for a long period of time. You just leave Texas and you go to one of the 20 or so other states who have abolished the rule against perpetuities as it applies to trusts, and now you could set up the trust to hold the weapons indefinitely for your family and keep those heirlooms. Like I said, many of the NFA weapons are of the heirloom character, that then those can be kept into the family. There was always a fear that our federal government will impose additional restrictions on the ownership or transfer of these weapons. Well, if you have them in a gun trust, they will be protected. Like I said, federal law may decide, let's impose the tax at current financial levels. And so they raise it to $4,000 or $5,000 to transfer a weapon. I mean, the gun shows will go out of business transferring these weapons. That would be something terrible. But if it's in the gun trust, then the trust is the owner, and even though there's different trustees over time, as long as you don't distribute it outright to a beneficiary sometime, if you keep the trust going like in a non-wrap state, then no transfer occurs, and you can retain the weapon for a longer period of time. Now, the federal government is considering imposing greater restrictions, which is ATF Rule 41P, which could spell the end of the gun trust. Because what this proposed rule would do is require anyone using an NFA trust to submit fingerprints, be photographed, supply proof of citizenship, and most importantly, because it's difficult to do, obtain chief law enforcement officer approval of every NFA item that is bought or sold by a gun trust. So this would really clamp down on this technique. Originally, when this came out, they figured that they were going to make a decision in the middle of last year, and this caused a huge run on the gun trust business, because they said, I forget, it was June maybe of last year or April, I forget, but it was going to be in the first half of last year, this rule was going to take effect. And so people were flocking to attorneys who do gun trusts to create these arrangements. The ATF got so many comments, many thousands of comments on this rule, that they have continuously delayed when they think it might be effective. I mean, in the middle of last year, they delayed it to the end of 2014. Then they delayed it to the beginning of 2015. And I just checked today, after I found out this is what you had elected me to do, and I found out that now it's May of 2015 is the earliest they expect any action. Of course, they could do, you never know what they might do. And so I do have a recommendation, that is, if a client has an NFA weapon, they should form a gun trust right away. You don't want to hang around. The benefits of a gun trust are so tremendous over outright ownership that anyone who has an NFA weapon should do it in a gun trust format. Now, some people think that there would be some other mechanisms by which they could hold the weapons. And it's true. They could use a business format. The ATF definitely allows you to own it by a corporation, an LLC, a family limited partnership, and so on. And although legally that will work and will solve many of the problems we have discussed, I personally do not recommend these other forms of ownership, despite the fact that they're legal, because there's a lot more stuff you have to do. It's a lot more complex to create these business arrangements than it is a gun trust. It also has a lot of material that then must appear on the public record. And doing a regular gun trust keeps, it's all private. There's nothing that ends up on the public record. The biggest thing that you need to avoid, and it's what your clients will do on their own, is they will get, this one's number 2. You don't want to put NFA weapons into trust with other stuff. I mean, the one that's taking care of the money for your kids to go to school or your grandkids to go to school, that's not the place to put any weapons. Whether they're regular guns or NFA weapons, they belong in separate trusts because there's so many separate rules, regulations, and expertise needed to handle NFA weapons that you do not want to mix them, commingle them with trusts that are set up for normal financial reasons. And then what I was also getting to say is that be careful of your clients who create what I would call the gun shop or internet trusts. Here's what happens. You go to the gun show, and you're looking around at the gun show, and you see that machine gun that you want, and you can afford it, and they say to you, well, you really can't buy that. You need all these rules and regulations, but you can form a gun trust. And now, sort of like with practicing law without a license, they have some forms there. And sometimes these have been mimeographed or photocopied so many times they are barely legible, and they're pretty horrible things, but people fill them out. And that's how they get their gun trust, filled with all sorts of terms and things that they've never thought about, they didn't negotiate, they didn't expressly agree to, and they're not prepared with sufficient expertise. You can also go online and either buy for a very small amount or even find free some gun trust forms. And again, these are not going to be personalized to carry out your client's intent, and I highly recommend that you do not use them. Instead, what you need to do is go to a lawyer who specializes in the creation of gun trusts. There are, as you would expect, many here in Texas that do this on a regular basis. For a long time, I attempted to get copies of gun trusts to include in materials when I present a seminar like this. And it took years of cajoling people before anyone would let me have copies of their gun trust to reproduce. They guard them as very, what we call it, intellectual property. They guard them, very strictly. But I did get authority to reproduce 2 gun trusts. They may not be the greatest in the world, but they are gun trusts that will give you an idea what needs to be in one. If any of you would like to see that, just send me an email, and I'll send you a copy of the entire article that I wrote that would accompany this presentation. Had I known before 10 o'clock that I was giving it, and it would have been in your materials. But I'll be very glad to supply that for you. So, that's pretty much it. I think I have about 2 minutes left. Does anybody have any questions or anything they want to ask? Yes? Nevada is a good one. Yeah, Nevada they still have RAP, but it's some long period. But the reason is they're more gun friendly, so you'll find more people there that would be able to handle it. Nevada is a good state. I am not certain, and I'm not certain if you would have to transport the weapons to the other state to create the gun trust there. I don't think you would physically have to do that. You could just create it there, even though the assets are here, and just change the ATF forms accordingly, since it is a federal government thing. Anything else? Yes, sir. The question is, do you need to have a co-trustee in Nevada to do that? Since it's not asset protection and not that type of trust where they usually require a domiciliary trustee, I don't know. I would think you need something, though, to domicile the arrangement in whatever state you pick to get their laws to apply. So I would recommend that you have a local trustee or at least a local co-trustee. Otherwise, you don't have any sufficient contacts with that state to trigger the application of their state law. Where's Professor Gonzalez? Jared, are you still here? Is that right? You think that'd do it? That sounds good. Okay. Well, you know procedure well more than I do. We got to have sufficient minimum contacts. Trustee should do it? You'll go with that. Very good. All right. Anything else, you guys? All right. That's it. Thank you very much. Good to see you again.
turn this on?